Well, we welcome you to this presentation on SK 1300, Simplified for Consultants. I won't claim to be an expert. I've just spent the last bit since they've passed the rules trying to figure it out. And so I'm not sure that I won't guarantee everything I say is 100% correct, but I think it is. So with that, we'll begin. I was looking over the participants, and I think you all know me. You know, I have 42 years experience, and I could go on for the entire hour on qualifications. You look at my picture, you'll see that I need a new one. That's about 6 years old, and when I look at that, realize my hair is a little more than I've got, and a few less wrinkles. But as we look through the SK 1300 regulations, I'm going to just start with the stuff in my presentation, which is available on mmsa.net if you want to download that. But it's been abstracted from various publications and sources. And I'll just say these are opinions expressed by me and should not be construed to constitute valid or a binding legal opinion. If you want a legal opinion, talk to an attorney. And with that, I usually don't do safety shares on my on a webinar or anything else. But a couple of weeks ago, while I was putting this together, a neighbor of mine was out putting lights up on his house for the holidays, and he uses a lot of lights. And I was out messing around in the yard, and I looked over and I noticed that he had was trying to finish getting things up to the peak of the house, and he had his ladder out and actually standing on the top of his step ladder. And we all know from our 100 million safety lectures that's a no-no. And you look over, and I saw that he was hanging on to the gutter with one hand, and the ladder was shaking underneath. And so I went over and held his ladder, and so there wasn't anything to worry about. But how often do we do as people, have our step ladder out, and you've just got that extra 2 or 3 inches you have to do, and you climb up on top of the top ladder, and it could be disastrous. You think the worst part about this case is he had his extension ladder just right around the corners, but he was up there trying to get things and almost fell off. And that makes for a bad holiday, and not getting the proper ladders out and everything else may save 2 or 3 minutes, but the trip to an ER room and everything else, it can ruin the holidays. And so remember, be safe and put up your Christmas lights if you haven't already safely. Now, when we look at SK 1300, always kind of why SK 1300? Well, regulation SK 1300 is a prescribed regulation under the Securities Act that lays out reporting requirements for various SEC K filings, such as your 1K, your 10K, your 8K, et cetera, et cetera. And I've put here public companies, but I do understand that if you've got stock and you're a private company, it applies to you too. The SK 1300 is the final rules to modernize the SEC's mining property disclosure regime. by improving the reliability of information to investors and by harmonizing disclosures with international standards. It is found in CFR, or Code of Federal Regulations, Title 17, Section 229.1300 to 1305, hence the term SK 1300. And this becomes mandatory for registrants disclosing their mining interest as of the first of this coming year. And if we look at what the SEC did, you'll see on this slide is they amended some stuff, they rescinded some stuff, but the two in blue is the important ones to look at because this is what they've added. They've added a new exhibit, 96 to 17 CFR 229.601B. And they've added basically 229, 1300 through 1305. Okay, and the things I've shown in black on this slide are essentially mostly paperwork to get all the federal regulations all synchronized and everything else. 801 and 802 was the old Industry Guide 7 that we used to have to deal with. And so, but the important thing are the two blue ones, is the 601B 96 and the 1300 to 1305 of the SK regulations. Now, when I first started looking at, okay, SEC's changed things, and you do the Google search and everything else, well, what's the final ruling? Well, you come up with this document, and I've put the link here. This document, which is called Final Ruling for Modernization of Property Disclosures for Mining Registrants, it includes commenters' concerns that on the proposed rules within that text, and it discusses why changes were made and what was changed to get to the final rules. It talks about paperwork reduction, final regulations, Regulatory Flexibility Act. And while this is a good document to understand if you're an academic like myself or an attorney and other things, it's 450 pages in length. Okay, and so because of that, after about an hour of reading, your head will probably explode and you give up on it. Because why? Well, we as consultants, we as the people that will be having to work with filing reports to meet these regulations, we're not interested in paperwork reduction or compliance cost or why a decision was made or not made and everything else for the final rules. We just want to know what we need to do. And that's the important thing, is what we need to do. And so as I was putting together things, trying to figure out how to put our reports together, I then went back and realized after all my research that the SK 1300 is not very complicated, especially if you've been working with NI 43-101 reports, as a lot of this stuff is very, very similar. And so what I found out is what you really need to do is to download and read basically the Code of Federal Regulations 229.1300 to 1305, which are the main regulations. And that's only about 27 pages. That's easy reading, okay? Other than it's written in lawyerese where it refers to section da-da-da-da-da-da-da-da-da, and you got to cross-reference, but it's not that hard of a reading and it's not very long. And then the other thing that you need to do is, even if you give up there, is you need to look at 229.601B96. And this is the thing that tells you exactly what you've got to do with your report. It gives you your instructions, it gives you notes, it tells you what you need to include, everything else. That's your roadmap to making it through an SEC, what they call a technical report summary. And what you need to remember as you're going through these documents is that the SK 1300 is all about disclosure requirements and regulations for disclosing mineral assets. And that you also got to remember it's also written for a mining registrant and their attorneys, not necessarily. And it covers both the initial disclosure of resources and reserves on a property and the ongoing disclosure requirements for those. And well, some of the stuff you're looking at, you may never have to deal with. Now, if we look at the SK 1300 regulations, like I said, it's 1300 to 1305. If you're looking at shortcutting your reading a bit, you know, read 1300, 1301, and 1302. Okay, when you get to 1303, it talks about summary disclosure and individual property disclosures and internal controls disclosures. And the last three is really what you got to do in support of your disclosures that you usually publish in your annual report, your 10K filings, that sort of thing. I put the link here to the electronic CFR stuff, but it's okay. Okay, you may have some problems with that when you download it. Okay, but essentially there's actually one report that you really have to worry about, and that's the technical report summary. And this is required for first-time reporting or disclosure of mineral resources or reserves. And this is what you need to be familiar with. Yeah, when you get to the summary disclosure section 1303, this really concerns you with periodic reporting and summary disclosure. They give you the options if you got a whole lot of mines to basically report in tabular form. And this is a mechanism for you to abbreviate your 10K filings and things like that. And we, in general, are not involved with this. It's usually the companies or the attorneys put all this stuff together, but it does require a qualified person's signature. And it requires a brief description of the projects and properties that will appear in the tables and stuff that you put in, and you have to do two tables, one for resources and one for reserves at the end of your fiscal year. And there's summary tables, and the hardest part about the summary disclosure is that you've got to divide things by countries and regions or states or groups or whatever. And the next slide, I've just put the table that they require, just kind of to give you an idea of things. You just fill these things out, you know. But as a consultant, like I said, probably this is a responsibility for the company or the registrant, rather than for a consultant usually doesn't get involved with this. Okay. And then the 1304 is an individual property disclosure. This is for your annual report also. This is after you've already submitted your technical report summary. You know, this is your annual stuff, and it's got a couple tables, one for resources and one for reserves, just like the summary one, which is if you've got a whole lot of properties. Okay, and here's an example that the regulations say you got to fill out this table. Okay, and so it's fairly simple. You put in the tonnage, the grade or qualities, cutoff grades, and metallurgical recoveries. Those are things that are important to put in your disclosure on an annual basis. Okay. Now, if we look at the disclosure reports that we're typically looking at, it allows for you to disclose mineralized material, what I'll call mineralized material. This is exploration results. And these are all optional. Excuse me, the disclosure of exploration results is optional. We look at it as the exploration results, we look at it as drilling reports and everything else. And the only thing you have to do, if you choose to disclose this in your filings, you just got to remember that tonnage and grade must only be expressed as ranges. Okay, then you get into the reports that say we've got resources, measured, indicated, and inferred. And they use the same definitions pretty much as the Cerisco template. And in SK 1300, the first of the five sections, it just gives you the definitions. And if you compare them with Cerisco, you're almost going to see it word for word. The common types of reports that we're normally involved with here, is your resource report or a scoping study or a PEA type thing if we're looking under what we file under NI 43-101. What must be done here is all you're doing is filing a technical report summary. But in order to disclose a resource, you must include an initial assessment. Okay, and then you can look in the regulations and you've got to address all these stuff in your initial assessment. And your initial assessment has got to have an economic analysis. Okay, and the big thing there, okay, is they've kind of leaned towards the PEA in terms of what they'll allow, and that says you can use inferred and do a cash flow as part of your economic analysis. But that's optional. You do not have to use a cash flow. You can do your justification that these will be, there's reasonable prospects for economic extraction, not using a cash flow at all. But the kicker here is if you used inferred mineralization for your economic assessment in your cash flow, you've got to present a cash flow without the inferred there. And most of the people that are so hot on producing PEAs for their property is if you don't include the inferred in your cash flow, more than likely the project really stinks if you've just got to, because you're still a lot of times with those still working on exploring, drilling, tightening up your resource estimate, And so, and the other thing is that if you do a PEA type assessment to justify declaring measured, indicated, and inferred, all the cash flow must have an accuracy, and the cost estimates within the cash flow must have an accuracy of plus or minus 50% and a maximum contingency of 25%. Then you get to the reserves, which is what we're used to under SEC. And they talk about preliminary feasibility and feasibility studies. They define what they are, and typically it's the same thing as you're normally dealing with. And you must, again, file a technical report summary. All these things you file what they call a technical report summary, which is described in 229-601B96. Okay. And your economic or your assessment must be well, you must use a cash flow for your assessment with a reserve, disclosing reserves, okay? And like is a standard every place else, is the inferred resources must be considered as waste. And they also have the accuracy and the contingency, maximum contingency range in that section in 1302. And that table 1 in 1302 is something you should be familiar with. Now, as you go through this, one of the regulations is the term initial assessment can be a little bit confusing, okay? And it's used in the regulations to find a technical and economic study in order to disclose mineral resource or update your mineral resource. And the report that's got to be filed as part of your SEC filings is just a technical report summary, okay? A special case of the initial assessment is when inferred resources is used in a cash flow to show the potential economic viability. And like I said, we're familiar with this because that's your PEA. Okay, but you got to be a little careful when you're reading the regulations because the term can refer to an actual report used by the QP, or it can be term is used to describe the economic analysis. Okay, but the report again is just the technical report summary that we've seen in 229-601B96. I hate all these terms, okay? But, we got to deal with them. The technical report summary, okay, is something that you have to file for an initial disclosure of either mineral resources or mineral reserves. And you've got to have a report for each material property. And you can go ahead and read this. It's not worth our time to go through all this because it's a lot of legal mumbo jumbo. Okay, but you've got to file this report if you want to present to your shareholders or to the public a mineral resource or mineral reserve. And the primary purpose of that report is to show that there is technical and an economic basis for you to claim that you have, 100 million tons at 1% copper or whatever it is, you're trying to claim. Yeah. And it's interesting as we get into this report that you're supposed to do is SEC, like the Canadians or like the Australians or anybody else, they start out, they say must not include large amounts of technical or project data or in the report or included as appendices, and that it must be written in plain English language. They try to stress that it's a summary. In other words, you don't need 100 pages discussing that, how the deposit was formed. Geologists, unfortunately, tend to like to write long reports about, you know, the uh, how people were back, you know, in the Precambrian, and then it went to the Jurassic, and then you know, a meteor came down from the sky and sprinkled gold into this deposit or whatever it is. You know, they like to do that. They just want short descriptions. You know, they don't want pages and pages of assays and drill results and everything. And they don't want hundreds of cross sections or variograms or plan maps, but they do require a little bit of this information. And again, one of the things that we as technical people have a hard time doing is writing it so it's understandable to a reasonably informed person. You know, but it's the interesting thing is they want short reports, but then if you go through 601B 96, you'll find that they require a terrible amount of information too. So you've got to trade off conciseness and shortness without sacrificing the content, so that a person can understand what's going on with the property. Okay, then we get to the 601B96 itself, and it gives you specifications as to what you need to include. Okay, and it's a prescriptive format. And if you read this slide, you'll see if you're looking at an exploration report, you need to include certain information. If you're doing, you know, just resources, you do this. If you're doing a report for reserves, you got to include everything, basically, you know. And the technical report summary, as I said, is very prescriptive in nature, and it has 25 major headings or chapters. And you should use all the chapters. And I'm going to say, don't skip a chapter, as you probably confuse, if not only the reader, but probably a bureaucrat that may be reviewing it. You know, if your economic analysis chapter happens to be chapter 12 instead of 19, you know, and we've all been to the DMV, and if you don't write none or something like that, you know, blank, they're liable to say they can't accept your application. You got to go back and finish filling it out, and then you got to get back in line, and that's liable to happen. So don't skip your chapters. If something's not applicable, say so, and why, after a chapter heading. Now, here's the 25 chapters, and we won't go through that, but they have instructions and comments in 601B96 for each one of these chapters. Okay, and that's the important thing. To be successful in writing a good report here, you need to read 601B96, and as you're preparing the report, refer to it to make sure you get all the required information. The thing to remember, though, is the SK 1300 report is not a 43101. If you look at the items required for an NI 43101, there's 27 of them. And there's a few things that's in different orders than is in the SK 1300. So read the required chapter contents carefully and make sure you include all the information. You know, and as I previously stated, if you got something that you can't cover, you know, if not, then why not? That's the important thing. And the other thing, when you start writing a technical reports summary and going through what's required, you'll find that the SEC really wants you to discuss the adequacy of the data or the risk involved for you to basically give disclosure as to why you think that the mineralization qualifies as a resource or reserve. And here's a couple of the examples of the required content. I've just put these up for just to show it as an example. And this is part of the geologic setting, mineralization, and deposit, and you do things like we normally briefly describe the regional, local, and property geology. Okay, and then it says including a summary of surrounding rock types, relevant geologic controls, length, width, depth, continuity of mineralization, with the description of the type, character, and distribution of mineralization. Okay, if we go down to 3, it does specify the qualified person must include 1 stratigraphic column and 1 cross-section of the local geology to meet the requirements of this section. So that, they require a lot of detailed information, but they want it in summary form. If we go down to the chapter called exploration, you get in points 3 and 4 here, they want a characterization of hydrogeology. And if we go down to the bulleted stuff, it says it must include descriptions of permeable zones or aquifer, flow rates, in situ saturation, recharge rates, water balance, and groundwater models used to characterize the aquifers, including material assumptions used in the modeling. Again, 4, you've got the same sort of stuff for geotechnical data. And so if you're used to doing NI 43 101s, a lot of this information you don't have until at feasibility level in the project. And again, this is requirements even for a resource. But remember, if you don't have the data, you just need to be open about it and say, we haven't done these studies yet. And why not? We just haven't had the time or whatever. If not, why not? Okay. People always ask about disclaimers, and SK 1300 is the same as most codes around the world, is that you may not disclaim responsibility for any information or documentation prepared by some third-party specialists. If you're signing off on it, you say you've reviewed it and you own it, type thing. But the interesting here with 1300 is there's actually a chapter, the last chapter, that you can outline what you have relied upon and data provided by the registrant. In other words, they don't expect you to have the expertise as in macroeconomic trends or marketing or legal matters. But this is the interesting thing, is they also don't expect you to have the expertise in environmental matters. While you're expected to have some, there are some things that may be outside of your qualifications and provided by somebody else. And you can go ahead and state that in chapter 25, along with, accommodations the registrant commits or plans to provide to local individuals or groups, in other words, some of the social issues and some of the governmental issues. Okay. We also want to look at the qualified person. And their qualified person stuff is pretty standard in there. You need to have at least 5 years of relevant experience in the type of mineralization and type of deposit under consideration. they add, and in the specific type of activity that the person is undertaking on behalf of the registrant. Okay, that's the important hook here. You know, a geologist can't be signing off on metallurgical processes unless they have the 5 years of relevant experience. Okay. In general, you know, if you're on this call, you're probably either a QP in the US or Canada here, and if you're a member of AIPG as a certified professional geologist, or a QP in the MMSA, or a registered member of SME, or a licensed professional engineer, you qualify. It's the same standards almost that you see around the world. Okay. And getting back to the relevant experience, you need to read the definition of QP in section 229.1300. And you'll see interlaced in here is things like relevant experience, mean for the purpose of determining whether a party is a qualified person. Just because you have a QP doesn't mean that you have the specific experience in the specific activity that you're undertaking. Okay, and it goes on to say, for a qualified person providing a technical report for exploration results or mineral resource estimates, relevant experience includes, in addition to experience in the type of mineralization, sufficient experience with the sampling and analytical technique, as well as extraction and processing techniques relevant to the mineral deposit. So you may need to make sure that if you're talking about 86% recovery, you've got a qualified person that can back that up. A quick comment, which is always a good comment, is you got to remember, QP, you as a QP should only sign off on the information you feel comfortable that you can defend in a court of law. Couple of quirks in the SK 1300 is the fact that, while we look at QPs as being individuals, it gives the option. A third-party firm comprising mining experts, such as professional geologists or mining engineering, may date and sign the technical report summary instead of and without naming its employees, member, or other affiliated person who prepared the technical report company. In other words, Barry Dobear, SRK, Jacobs, Samuels, all those firms can produce an SK 1300 technical report summary and not have any of their employees sign it. The company basically signs it. And the other quirk is there's no requirement that the QP be independent of the registrant or the company for any of their filings. And the comment I'll have here is most companies will have at least one top executive or board member that is a professional engineer. That means they can serve as the QP for any filings on resources and reserves, because there's no requirement for independence. Most people are concerned about liability because this matter came up in the proposed rules rather than the final rules, but the final rules do not provide a complete exemption for qualified persons from expert liability under Section 11 of the Securities Act. That means a minority shareholder can name you as part of a lawsuit against the company and the board of directors. we tend to be, so you've got to be able to defend your work in a court of law, you know. And the only advice I'll give here is check your professional liability insurance and if it covers that sort of stuff. If it doesn't, you may want to push that final signature onto the a PE within the company, which will have or should have some sort of insurance there. Materiality of a property, because that's a term that keeps all through, is materiality, that's not your responsibility as a consultant. It's the responsibility of the company and their attorneys. Okay. But to make a quick comment on this is generally a property is considered material if it constitutes 10% of either the company's revenues or its assets. If you're an exploration company and you have two properties you're looking at, probably both of them are material to your market cap on your stock. But they also say, they looked at sand and gravel operations and say, this sand and gravel operation has 20 different mines going on, and none of them generate more than 5% of their company revenue. So they're not material properties. Yes, they are. Because they aggregate things as operational units. If your operational unit it consists of more than 10%, and they don't give the 10% rule. That's what the financial peoples tend to. They've kind of left materiality open. Leave that to the attorneys. Let them beat their heads against the wall there. In terms of mineral disclosure, if we look at the individual property disclosure in 1304, it gives a table here that you've got to use in your annual reports. Okay, this one's for resources, this one's for reserves. Once again, these are tables. My recommendation personally is to use them. Use them in your technical report summary. The last thing you want is some bureaucrat saying you haven't put it in the right table. And I have experience with that because when we were doing the Singapore exchange, there says you got to use this table. I made a modification to the table because the table didn't make sense for the property we're using. And the report got rejected by the bureaucrats because it wasn't exactly what they wanted in their reports. So use these tables. That's a suggestion, not a requirement. Okay. In summary, as we're closing things out here, is download CFR Title 17, Section 229.1300 to 1305, and the 229.601. And I've got links on the next page. The read, if nothing else, 229.1302 and the 229.601B96. Make sure you familiarize yourself with requirements for the economic analysis or initial assessment. And don't get carried away on their report called initial assessment, because it's just really a process. Okay? Assemble the technical report summary for the property. And remember that the technical report summary should be a summary of the technical work and not the actual resource study or PSS or feasibility study. And pay close attention to the instructions. And remember, something you get stuck on and it's not applicable, Just remember, if not, why not? And you got to remember that if you are doing a PEA style report, which includes inferred resources in the cash flow, you must also present a cash flow without using inferred resource. There's no requirement for an independent QP. So you're probably better off to push the liability back onto the company when you can. Let the company and their attorneys deal with materiality of properties and what properties actually need a technical report summary. You know, it's your responsibility as a consultant to do the report. It's the company and their attorneys' responsibility to say, hey, we need to contract you to do a report. You know, and again, just the reminder is 1303, 1304 is more slated towards annual reporting requirements. 1305 is a very small section that says, but you've got to discuss QA, QC on your data with stuff you put in 1303 and 1304. I've got, like I said, I've got two files here that I've basically downloaded the regulations, cleaned them up so they're a little more legible and easier to look at. And these are the two links. And this entire presentation will be available on the available on the MMSA website. I checked that before we started at www.mmsa.net. And I'll say, please, putting up your Christmas lights, don't stand on the top of your ladder. Have a safe and happy holidays. And now I will open this up for questions.
Thanks a lot, Bob. There are a few questions in the chat. You may see them. Tom Dyer asks if the cash flows are required to report pre or after tax.
That's a good question, and the cash flows must be after tax.
Okay. Ta Lee says, with the new amendments, did the qualification of the authors change significantly?
I'll try to answer that one. The qualifications of the authors have not changed significantly, as far as I can see. They're the final rules basically took out some of the restrictions that was in the initial proposed rules that went out to the public and relaxed some of the requirements. And part of the requirements they relaxed is being able to basically rely on information provided by the registrant but you've got to disclose that in chapter 25.
Okay, Art Ibrado asks, so if my company is the QP, there wouldn't be a signature required on the report. That is, no need for someone to sign for the company.
That's actually, I would say it's my understanding that would be incorrect. If well, I'll rephrase that. If you're a consulting firm, the consulting firm can be the QP. There does not need a signature on the report, but the consulting firm assumes the Chapter 11 liability. I think that's where what he's headed with that. You know, if I'm the mining company that's producing my own technical report summary, you've got to have a signature from somebody in the mining company. That's how I read the regulations. I may be wrong there.
Fernando Rodriguez says, dear friends, it is important for everyone to know that the majority of the liability insurance that we all have excludes new SEC filings. Don't assume that you have this insurance. SRK NA North America had to get additional liability SEC insurance and increased our insurance by a factor of 5 times. Great presentation.
Well, I'll just say this, Betty. I think you're trying to put together something a little more definitive on liability insurance for a future presentation.
Yeah, right. We will be having at least one more SK 1300 webinar. One will probably be coming up in January. It isn't quite set yet. Okay. Dennis Ferrigno says, thank you, Bob. Excellent presentation. Best to you. And that looks like all the questions that we have.
There are a few in the Q&A, I think.
Oh, yeah, we do have 2 more in the Q&A. Dennis Ferrigno also asks, is there a requirement of a foreign company owning a property in the U.S.? Would they be required to file a SK 1300 report? And he clarifies the question is for a foreign company privately held.
If you, that's a good question. I'm not sure I can answer it 100%. But it's my understanding if you have to file anything with the SEC, then yes, you would be required.
Okay, I think that's all the questions. Will there be a certificate, Louis Kleinhans, will there be a certificate substantiating participation in this seminar? And usually we don't give certificates, but we can if that helps you. If you just make a note in your continuing professional development that you attend in the webinar, we also do have your name as being a participant. So it's not really necessary to have a certificate, but if you really want one, we can make one.
You missed the question from Keith. Okay, and about any comments of royalty companies.
Okay, go ahead.
And I'll just say, if you're a royalty company, they've really bit you in the butt on these, because it seems like everything you have is considered material, and you need reports on it, and there's a lot of discussions on royalty companies, and but there are also several exemptions from royalty companies. For example, if you can't get the information from the operator or whatever, then you need to work with the SEC to tell them that, that sort of stuff. So, while they require everything on all your royalty interests, there are some, they're not, it appears that they're willing to negotiate a little bit. And that's just my impression. I can't say that for sure.
Okay, Dennis Ferrigno asks, is the royalty company material even if they have a small percentage ownership in the property?
The materiality question is, again, something that needs to be discussed with the company and the securities, their securities attorneys. But it appears that even if you have a small royalty interest that you're creating revenue from, and you're a royalty company, they consider that's part of your income stream, and so they consider that material. Okay, that's how I read it. And I'm not an attorney, so I can't give a legal opinion on that.
Okay, Yusuf Dafi says, great presentation. Thank you very much. In terms of precision, what precision to attribute to each category of resource?
The SEC actually uses the same definitions as Cerisco, and in terms of inferred, indicated, and measured. And they just say that one has a better, measured's the greatest, inferred's the least, and it's, where continuity can be inferred between two data points and a few other things. So they don't really give a hard limit as to what the accuracy or the precision in each of the resource categories. It's kind of left up like in all of our filings. It's up to the geostatistician and the geologist to look at whether you can infer continuity, or the continuity is indicated, or the continuity has been demonstrated for the three different resource categories. And the interesting thing is we talk about resources and reserves, and we talk about measured resource, and measured in mining circles isn't what lawyers and accountants think measured is, because measured in mining circles can be anywhere to plus or minus 10 to 15 to 20%. Whereas when you talk to the normal person on the street, measured is something, you're not guessing at. You figure, that there's 10.7 gallons in your gas tank or something like that. So, but that's a very good question.
Another question, this is from Bob Rowe. If a registrant has filed multiple years of reserves in its 10Ks and has many years of operating experience at a mine, is a tech report summary necessary?
I haven't really researched that question, so I can't give a good answer. You got to remember that these, so that would be an answer to ask, call the SEC and ask them, that. I think that it might be required, but what they're really looking at is, can we rely on what you're telling the public? And if you're an operating mine, basically your market cap is based on the revenues you're producing and not how many resources and reserves that you have. Is very typically, unless you're running out of resources and reserves and haven't been replacing them.
Bob says, good answer.
Okay.
And that's all the questions I see.
Okay.
All right,
Susan is
then.
going to close out.
Well, thank you, everybody. And Betty will get this edited and posted up on our website in a few days. It takes a little while to get everything edited. So thank you very much, Bob.
Thank you. And thanks for all the people that put up listening to me today.
It's an important topic. All right, thanks. Bye, everybody.